Good afternoon. Today, the Rules Committee will consider H.R. 4768, the Separation of Powers Restoration Act of 2016. Since the Supreme Court case of Chevron USA Incorporated versus Natural Resources Defense Council, courts have regularly deferred to agency interpretation of ambiguities and ambiguities and gaps in statutes when agencies administer laws. The courts have similarly deferred to agency interpretations of their own regulations since Iyer versus Robbins, encouraging agencies to write vague regulations so that they can then interpret them at their own whim without a sufficient check from the judicial branch. Excessive and often unnecessarily regulated rules by federal bureaucrats strain family budgets, create conditions where businesses, including small business and large business, has compliance teams that struggle to work around these agency rules and regulations. H.R. 4768 directly benefits the American people by ensuring unelected bureaucrats are not able to reinterpret the intent of legislation that was passed by lawmakers directly on behalf of the people of the United States. Restoring this proper judicial role under the Constitution is vital to returning accountability in the regulatory process and reining in what I consider to be unlawful federal agency regulations. I would like to welcome today, if we can, the gentleman from Texas, John Ratcliffe, who is representing the chairman of the Judiciary Committee. I've been advised that Mr. Hank Johnson, Congressman Johnson from Georgia, would be joining you in just a few minutes. We're going to go ahead and proceed, not wait for him to be here, with the knowledge that the gentleman from Texas, without objection, will be allowed to enter his statement into the record, and the gentleman's now recognized.
Thank you, Chairman Sessions, for the opportunity to testify today regarding H.R. 4768, the Separation of Powers Restoration Act of 2016. I introduced H.R. 4768 in its original form on March 16th of this year. The Judiciary Committee ordered H.R. 4768 favorably reported on June 8th, 2016. Mr. Chairman, the need for this legislation to restore balance in our federal system is, I think, very clear. The modern federal administrative state is an institution that is unforeseen by the framers of our Constitution and is now rapidly mushrooming out of control. The Separation of Powers Restoration Act of 2016 takes square aim at one of the biggest roots of this problem, the Chevron doctrine, under which federal courts defer to regulatory agencies' self-serving interpretations of the statutes they administer. This includes interpretations like those that underlie the EPA's Clean Power Plan and Waters of the United States rules and the FCC's net neutrality rule. Similarly, this bill takes on the related Auer doctrine, under which courts defer to agencies' self-serving interpretations of their own regulations. Mr. Chairman, the founders built in a separation of powers to prevent one body from writing and interpreting the very same laws it has the responsibility to enforce. That is why, in perhaps one of the most famous Supreme Court decisions, Marbury versus Madison, Chief Justice Marshall declared for a unanimous court that it is emphatically the province and duty of the judicial department to say what the law is. But since the Chevron doctrine allows judges to evade interpreting law and instead to defer to agencies' interpretations, one has to ask, is Chevron faithful to Marbury and the separation of powers? Similarly, in the Administrative Procedure Act of 1946, often called the Constitution of Administrative Law, Congress provided for judicial review of agency actions in terms that were very plain and very direct. It stated that the reviewing court shall decide all relevant questions of law and interpret constitutional and statutory provisions. That standard is consistent with Marbury and the separation of powers. But again, because Chevron allows judges to escape interpreting statutory provisions themselves, one must also ask, is Chevron unfaithful not just to Marbury and the separation of powers, but also to the Administrative Procedure Act? These aren't just academic questions. These are fundamental questions that go to the heart of how our government works and whether the American people can still control it. Judicial deference under Chevron weakens the separation of powers, threatening the liberty of every American because it bleeds out of the judicial branch the power to interpret the law, transfusing that power into the executive branch. At the same time, it tempts Congress to let the hardest work of legislating bleed out of Congress and into the executive branch, since Congress knows judges will defer to agency interpretations of ambiguities and gaps in statutes that Congress did not truly finish. This leads us down the dangerous and slippery slope that James Madison warned against in Federalist 47 when he said, "The accumulation of all powers, legislative, executive, and judiciary in the same hands may justly be pronounced the very definition of tyranny." The Separation of Powers Restoration Act of 2016 is timely, simple, but bold legislation directed straight at stopping our slide down the dangerous slope. In one fell swoop, it restores the separation of powers by legislatively overturning the Chevron doctrine and the related Auer doctrine. Mr. Chairman, this is a reform that we must make a reality for the good of the American people. One need look no farther than the D.C. Circuit's decision just last week to uphold on Chevron grounds the FCC's net neutrality rule. That rule would regulate the internet like the 20th century telephone monopoly, contrary to congressional intent, but according to the D.C. Circuit, Chevron lets it happen. I therefore request that the Rules Committee grant an appropriate rule that allows for expeditious consideration of H.R. 4768, and I thank you all for your time today and yield back.
Thank you very much. I note that you are amending in a very specific way Section 706.
Yes, Chairman.
And in doing so, you chose that because it's the judicial rule of statutory and regulatory interpretations. Are there other sections that necessarily discuss this in the law?
Well, Mr.
This is very narrow.
It is narrow, Mr. Chairman. The intent here, as I said, this is a simple bill. I think that the Administrative Procedure Act was very clear, but obviously not clear enough for the Supreme Court to issue the opinion that they did in the Chevron case. So the bill literally, I think of as more of a clarification than an amendment of the Administrative Procedure Act, and the specific clarification is I added 8 words that essentially call for a de novo review, which is a fancy legal term for of the new or starting from scratch, which I think didn't really need to be said, but I do think it clarifies the point. And as the chairman well knows, because of Chevron, instead of litigants to a regulation entering court on level footing, the agencies come in with a head start because of the deference that's provided to them.
Ms. Ratcliffe, I want to just applaud you for not only accepting the responsibility of running for Congress, but to thank you. Your service to this nation as U.S. Attorney in a most difficult period of time, especially in North Texas, where you dealt with many issues of not only national security, but of commerce. And I want you to know that I looked at your service with great admiration, and I'm delighted to have you now as a colleague. And thank you for taking time to be with us today. Mrs. Fox?
I thank the chairman for his kind words.
Thank you, Mr. Chairman. I learned a lot about our colleague just now from those comments, and I appreciate that. I appreciate your being here, and I appreciate your taking the lead on what I think is a very, very important issue for us to be dealing with. As we talk about regaining Article 1 powers, I have said for years, it is not just a matter of our dealing with the executive branch, it's also a matter of our dealing with the judicial branch. And this bill, in effect, is a twofer for us and helps us in both of those areas. And so I appreciate it very much. I know that our colleague from Texas is one of our members who doesn't get on the floor and speak a lot. He's very quiet and reticent, but he will let his work and his legislation speak for him. So I thank you very much. I have no questions, but I appreciate what you're doing.
Again, I thank you for the kind words.
I yield back.
Thank you very much. Chairman Cole.
Thank you, Mr. Chairman. I, too, want to associate myself with the chairman and the vice chairman's remarks, and appreciate very much, Mr. Ratcliffe, what you're trying to accomplish here. It's something that's long overdue. When I talk to my constituents, probably the greatest single frustration is that they believe that the federal bureaucracy has basically made rulemaking authority into lawmaking authority. And they see they change members up here, but they don't see much of a change of direction. And they don't have any way to get at, if you will, the bureaucrats that they disagree with pretty profoundly on decisions and that are quite often at odds with the legislation that their elected leaders have given. So I think this is a really important step in the right direction. And you and your entire committee are to be commended because I see you reclaiming the power of Congress and, frankly, nudging the courts to use their own power in an appropriate way. Neither the judiciary nor the elected members of Congress ought to be in a position where they're effectively subordinate to unelected officials. And that's happened over and over and over again in instance after instance. So this is a really important issue, and I think one that should it become law, as I hope it will restore the faith of the public that the people we elect, are going to have the ability to put the country to go in the direction that we want it to go. Absent this, I think they are very much at the mercy of unelected officials who they quite often disagree with. So this is really, really an excellent piece of legislation. So I just want to also commend the gentleman. And with that, Mr. Chairman, I'll yield back. I have no questions. I just am very appreciative of what you're trying to accomplish.
Well, I thank the Congressman, and I'd like to associate myself with your comments because I think you've encapsulated the issue at hand very well.
Thank you very much, Chairman Cole. Judge Hastings, do you seek time?
Yes, Mr. Chairman.
Gentleman's
Mr. Chairman,
recognized.
I was not here to hear our presenter witness, and I appreciate very much him being here. But I did get here in time to be handed the Statement of Administration Policy, and with the Chair's permission, I ask unanimous consent that it be made a
Without
part of the
objection,
record.
be included in the record.
Mr. Chairman, it's only a paragraph long, but it speaks volumes to the 3 decades of history that I'm mindful of as a lawyer and as a former judge. Chevron USA Inc. versus Natural Resources Defense 3 decades ago, referring to Section 706 of the Administrative Procedures Act, to authorize reviewing courts to decide de novo all relevant questions of law, including the interpretation of constitutional and statutory provisions and rules made by agencies. The administration says the following. I don't think it comes as any surprise to anybody that the president would veto this measure if it were to gain force and pass the House and the U.S. Senate. The administration strongly opposes House passage of H.R. 4768, and because it would unnecessarily overrule decades of Supreme Court precedent. It is not in the public interest, and it would add needless complexity and delay to judicial review of regulatory actions. Footnote there, our courts are already understaffed and overworked, and we need not thrust upon them, not just the Supreme Court. I remind people that very few cases get to the U.S. Supreme Court, most of them in federal court end and begin. at the United States District Court legislation. Continuing on with the administration's position, this legislation would allow federal courts reviewing an agency action to conduct de novo review of all relevant questions of law without deferring the legal interpretation to the legal interpretation of the agency. Both federal statutes and case law provide federal courts with the appropriate tools to review regulatory actions and afford appropriate deference to the expertise of the agencies that promulgated the rules and regulations under review. If the president were presented with 4768, his senior advisors would recommend he veto the bill, and I too would recommend that he veto the bill. Mr. Chairman, I don't want to ignore the fact that ongoing on the floor of the House of Representatives is an effort on behalf of the Democrats in the House of Representatives to bring to the floor of the House some sensible gun measure that will allow for a vote to be had. I was there all day at the beginning and until I decided that I would come up here and at least be present during the Rules Committee proceedings. I can't tell you how heavy my heart is that this body, never mind the litany of all of the horrors that have taken place in our society. Many of us in this room have witnessed them. When I spoke earlier, I asked how many people had situations of gun violence, not necessarily mass shootings, and every member there held their hand up. And if there were 435 House members and 100 Senate members and 6 or 7 delegates of the United States House or country, all of them would hold their hands up because gun violence is rife in our society. 33,000 Americans killed last year, headed in that direction again this year. Countless children, even unborn children, killed in their mother's wombs with gun violence. And never mind casting aspersions on the NRA and gun manufacturers, the aspersion should be cast on all of us. And how dare the Speaker of the House of Representatives and or his leadership or any of you cut off the microphone. That has only happened one other time. Louise, you may remember when Newt did that once or before. That's absurd. We came here at the instance of just as many people as any one of you in this room and any member of the House of Representatives. Now, I didn't come up here with that kind of speech in mind, but I think it is wrong for us to continue doing nothing. And that's what we're doing. This ain't going nowhere. The financial services measure isn't going anywhere. The measure repealing the so-called Obamacare isn't going anywhere. And you all know it. So why don't we just fold the tent and go home rather than sit around here pretending to the American public that we're doing something. If we can't bring at least a sensible gun measure, and I think my colleagues are going about it the wrong way. They are asking for something that everybody ought to agree with. No fly, no buy of a gun. How easy is that? Let alone background checks. Let alone all the other things that are needed in the assault weapons ban. You, Mr. Chairman, and I and Louise were here when we repealed the assault weapons ban, and we were here when it passed in 1993 or 94. It's ridiculous that we continue down this path with our children, our citizens, our constituents dying with regularity, while in the final analysis we're doing nothing. And oh, no, not this time, I don't think you will. What I said before I left is fine. They may stop us today, but we will be back tomorrow. And if nobody but me stands on the House of Representatives and says no more, are we going to sit around and allow for us to be manipulated by manufacturers of guns in a way that's unnecessary. Tammy Duckworth, a wounded warrior, was on the floor. And she mentioned when she went into Fallujah, and she was a helicopter pilot. She's one of our colleagues. She mentioned when she went into Fallujah, they had assault weapons. But the assault weapons that our military had did not allow for the repetitive firing that the weapons that were used in Sandy Hook and in Orlando were. You should be ashamed, every one of you, sitting up in here and allowing for this to continue. Now, I know you're going to have some other measures, and I'm not finished with what I'm going to keep saying until such time as each one of us is on record saying how we feel about whether or not people ought to have guns. Another thing that I said, and let me repeat it, I own 2 guns, and immediately when I purchased them, I registered them with the police. I recently got rid of those 2 guns and bought 2 more. I stood there until they completed the background check, and I have no problems in that regard. With all of the weapons in our society, how dare anyone out there think that somebody, I guess it's going to be our military, I guess it's going to be our police officers, somebody's going to come out there and going to take all of the guns from all of the people in America. How crazy is that? That ain't happening in our society. And I defy anybody to walk up to my house and my family and think they're going to take my gun. I stand with those who believe in the Second Amendment. But I do not stand with anybody that believes anybody other than the military or police officers ought to have a weapon. I'll stop right now, Mr. Chairman, but I'm not finished by any stretch of the imagination with allowing that we continue protesting, and perhaps it'll stop today, but I will be among those who will try to make it start tomorrow. No gun bill, no break. I yield back.
Gentleman yields back his time. Thank you very much, Mr. Johnson. We made a decision to move ahead without you, knowing that you would be here, your choice, but the gentleman's now recognized without objection. Anything you brought in writing will be entered in the record.
I thank the chairman for this opportunity to speak in support of my amendment and in opposition to H.R. 4768, the Separation of Powers Restoration Act of 2016. I come straight from the floor where I have been engaged in a sit-in that is demanding that before we take a break, we take a vote. And I know that we'll be voting on H.R. 4768 before the break. Judicial review of final agency action is a hallmark of administrative law and is critical to ensuring that agency action does not harm or adversely affect the public. But as the Supreme Court held in Chevron v. Natural Resources Defense Council, reviewing courts may only invalidate an agency action when it violates a constitutional provision or when an agency unreasonably exceeds its statutory authority as clearly expressed by Congress. For the past 30 years, this seminal decision has required deference to the substantive expertise and political accountability of federal agencies. As the court explained in Chevron, quote, federal judges who have no constituency have a duty to respect legitimate policy choices made by those who do. The responsibilities for addressing the wisdom of such policy choices and resolving the struggle between competing views of the public interest are not judicial ones. Our Constitution vests such responsibilities in the political branches, end quote. That is our law. H.R. 4768, the Separation of Powers Restoration of the Separation of Powers Restoration Act of 2016 would eliminate this longstanding tradition of judicial deference to agencies' interpretation of statutes and rules by requiring courts to review agency action on a de novo basis. At a minimum, this bill will delay and possibly derail the ability of agencies to safeguard public health and safety. Without any constraints on judicial review, however, the bill will also incentivize judicial activism by allowing a reviewing court to substitute its own policy preferences for those of the agency, which Congress has specifically entrusted with rulemaking authority. In other words, this bill resolves a perceived imbalance between branches by granting immense authority to the judicial branch so that it may act as a super regulator through judicial fiat. In a letter opposing this bill, a group of the nation's leading administrative law professors underscored this point, arguing that the bill is motivated by policy disagreements, not actual concerns with deference. So in other words, they're saying that when you stack the courts with right-wing, free-market conservative thinkers and then give them the authority to de novo, to review agency concerns and decisions in a de novo setting, then judicial deference will be cast away and judicial activism will replace it. And that is not what our founders anticipated. It's actually smacks of unconstitutionality. So in closing, I strongly oppose this measure, and I ask that my amendment be made in order to address these concerns. I will be heading back down to the well of the House to sit in with my colleagues from both the House and Senate. We've had a great showing of support from our colleagues from the other side of the Capitol. We're all there, we're all speaking, and we hope that the American public hears us because the microphones have been cut off. But we can't be stopped. And so with that, I will yield back.
Thank you very much. Mrs. Slaughter, would you care to question the gentleman? Or either of our gentlemen?
No, I really don't have any questions because I agree with my colleague, Mr. Hastings. This bill isn't going anywhere. And if it should, it's going to be vetoed, as it says here. And once again, we're just up here spending time. So, but if I can take a little bit of time, I want to talk to my two colleagues who were on the floor. And to people who may not know this, that there was a time in the United States not very long ago when we had assault weapons bans were not allowed to be on the street or to be in civilian hands. And things were really better then. There wasn't all this mass shooting. You might want to know that since Newtown, where those 6-year-old children were shot to pieces by those military weapons, that since that time we have had 988 mass shootings in this country. A mass shooting is one of 3 or more victims. Now, if you can think of another country in the world, even some of the most primitive or some of the most assertive that would put up with that, there just isn't one. And for the world's greatest democracy and the greatest deliberative body, we're not deliberating on a heck of a lot. But we won't touch it. It cannot be done here. And if you don't know it, there are even more things that I find egregious. We did the health care bill, Elsie and Hank, if you remember. And it was inserted in there at the request of the NRA that no doctor can ask his patients if there's a gun in the house. And the doctor can ask his patients if there are drugs in the house. Guns, no. And the CDC does all the research on medicine here, was forbidden in the health care bill to do any research on the violence that takes place in the United States. Every single avenue that you might think of that would bring some normality or some reason to the gun culture that pervades is blocked out by legislation here. So you understand that a lot of us have reached the breaking point. And we're trying our best to try to do it. And I know all the members in this committee, good people who wouldn't do it. I'm not really sure what it is, whether it's contributions or what fear. I don't really know what causes that kind of motivation. I can't believe it. I really thought, and I bet all of you did too, that once and we knew about Newtown. And that crazy kid walked in there with guns his mother had bought for him and just mowed down the 2nd grade. I mean, you know, we've really reached a stage in this country where when people you love leave home, to go to work, to go to church, to go to a restaurant, to go to a theater, to go anywhere, their chances get worse and worse that you will ever see them again. I mean, I think about the people at church, at Mother Emanuel Church in Charleston. They came in to do Bible study. Now, all my life, I grew up thinking a church was a sanctuary. If there was really trouble, you made it to the church, you were okay. No more, we don't have that anymore. In fact, over the years, we started to keep some records of how many ministers were shot in the pulpit, how many people were killed in the Sunday school. There is no sanctuary here. You're on your own. So I don't know what to do. Maybe we don't have an amendment, apparently. And whether we're going to train Americans to jump over bullets, that's going to be a pretty hard job, given the obesity records in the country. But that's about our last hope here, that we can get such athleticism. When we see a bullet coming, we're apt to do that, right?
Would the gentlelady yield just 1 minute?
Sure.
Yeah, include in the sanctuaries Sikhs and temples.
Indeed, in
where
Tucson.
people have been shot. In
Yes.
addition, if you will continue to yield, I misspoke with reference to the chairman's period of time here in the House of Representatives. I stand corrected that he came here in 1997, so he was not here when you and I were here when we passed the assault weapons ban, and later when it was repealed. But all I'll say to you, Mr. Chairman, it just seems like we've been here, I guess, because we're in rules a lot, it seems to me like we've been here almost all of my life. Yeah.
Well, reclaiming my time,
Thank
I'm
you.
sure that my colleague also remembers that people lost their seats because they voted for sensibility in guns in the United States. So I think that's really why we all hate standing for one moment of silence, which, as far as I'm concerned, is one of the most hypocritical things in the world, because we are standing in one moment of silence and to try to honor people who might not have been killed if the people I'm standing there with had really done their job. Our job is certainly to protect the people of the United States of America. That's the oath we take. But when it comes to guns, and let me tell you, I've said this before, and everybody knows it, but I came out of eastern Kentucky, where everybody was hunters in my family, but nothing was ever shot that wasn't for dinner. And it was, despite the fact that everybody had guns in those days. And let's think about the Second Amendment a minute. Somebody said it wasn't me, it was somebody much more cleverer than I. The Founding Fathers never intended for anybody to have automatic weapons. They had muskets. And somebody said, we let people have all the muskets they want. We might at least have a chance to run away from it. But these bullets, that reign of terror, when I think of those children, picture that awful death, if you can, for a minute, if you can bear to do that. And yet we shrugged, we really felt awful about it. It was Christmas time, kids were all ready for the holiday, we saw their parents. We really, for the first time I can say this, we felt their pain. But then we go back to work, if somebody tries to do something about guns and we can't get anywhere. And I think, from what I can see from my colleagues, and I'm 2 pages away from being able to speak, we're not going to give up this time. I don't think we believe we can. It would really be great if we could all together strike that blow, as we've done before in the past, in the interest of the American public. I know my phones will ring off the wall up there, what we're doing, and to make sure that we hope that we can get something done. But the polls show it. I think it's something like over 90%. These are Republicans and Democrats and independents and everybody else. Over 90% of them think that if you are on the terrorist watch list, you shouldn't get on an airplane. And background checks need to be really strengthened, frankly. I think the rule is, I believe that they have to destroy them, don't they, in 24 hours, something like that? So nobody else can ever look at that and see what they said. But we need to have them to have meaning, and we need to appeal to all our countrymen. They just in New York City, I think today, they found a car at one of the tunnels. These were nothing to do with ISIS or any terrorism at all. They were doing some revenge, I believe, whatever it was. You never saw such a weapons cache they had in the back of this car. Everybody shouldn't be having those weapons. We know that. And I would sure like to have the medical profession be allowed or frankly, there should never have been a law written that they couldn't, but I'd like to remove that so that we can have a better chance of finding people who simply are not capable of handling that, or people whose mental problems are so great that what they really need is help. So with that, let me yield back my time, and I appreciate your giving it to me, but it's gone on long enough. Our colleague from Chicago just said 46 people were shot over the weekend in Chicago, 13 died. Do you want to live in a town like that? Wouldn't you rather live in America where you could go somewhere and go home? Wouldn't you like to go to church and about 6 o'clock do Bible study, and then go home and have dinner with your family? I wish everybody really understand that the possibility sometimes of getting back home in this country is getting more and more remote. So thank you again.
Chairwoman Jill's back to time. Thank you very much. Gentleman from Louisville, Texas, does not seek time. Does any member of the committee seek time with either of our witnesses? I want to thank both of you for taking time to be here, and I appreciate your time. If you'll please make sure anything you brought in writing will be left with our awesome stenographer, and thank you very much. Mr. Yoho, I note that you had made a request to come speak with the committee. Does the gentleman wish to do that? Yes, sir. The gentleman is welcome to the committee. Without objection, anything you have in writing will be entered into the record. And if the gentleman please make sure that microphone is on and up close, and we appreciate you. Dr. Yoho, you're now recognized.
First off, I'd like to thank all of you for being here and again for what you do. I've said that over and over again. Without you, nothing goes forward. I'd like to quickly thank Chairman Sessions, Ranking Member Slaughter, and the members of the committee for allowing me the opportunity to speak on behalf of my amendment. In 1983, the U.S. Supreme Court made an unprecedented ruling in Immigration and Naturalization Service, INS versus Chadha. The Supreme Court ruled that the one-house legislative veto violated the presentment clause of the United States Constitution and effectively tipped the scale of the balance of power in favor of the executive branch. INS versus Chadha was never intended to be a case resulting in a ruling with the size and the scope of which it did. Justice Powell decided with the majority, but argued about the dangerous precedent the Supreme Court ruling was establishing in invalidating all legislative vetoes. After all, the use of the legislative veto has been a long-standing practice between the Congress and the executive branch, a tool to keep the executive branch in check. Justice White, in his dissent, stated, "Without the legislative veto, Congress is faced with a Hobson's choice, either to refrain from delegating the necessary authority, leaving itself with the hopeless task of writing laws with the requisite specificity to cover endless special circumstances across the entire policy landscape, or in the alternative, to abdicate its lawmaking function to the executive branch and independent agencies. To choose the former leaves the major national problems unresolved. To opt for the later risks unaccountable policy making by those not elected to fill that role." We are now over 30 years out from the Chadha decision, and we can see how the Congress has been left in a position subservient to the executive branch and the administrative agencies. We clearly have a 30-year-plus retrospective study of the unintended consequences. Rather than act in a matter coherent to the Constitution's Take Care Clause, the executive has been left with unchecked authority to change the law as it sees fit. As a result, Congress has attempted to use the Congressional Review Act to retroactively reassert congressional intent and rein in executive agencies. This week, for example, we are voting to override the president's veto on a CRA to nullify the Department of Labor's definition of a fiduciary. This, unfortunately, has become the norm for Congress, acting after the fact. In fact, Congress has only successfully used the CRA once, and that was because it was in the year 2000, presidential election gave way to President Bush assuming office, and he signed that. What my amendment would do is prevent bad regulations that run contrary to congressional intent from ever being enacted in the first place. Agencies would be required to submit for approval any proposed rule to the House and Senate committees of jurisdiction, while rolling back the implications of the Chevron versus Natural Resource Defense Council is a step in the right direction, and I applaud you for looking at that. We as an institution need to do more to restore our constitutional powers. We need to be proactive and not reactive. This is one of the most important issues to me personally and the American people. We talk about fundamentally transforming America. I think America's pretty fine. You know, it's got some problems. What needs to be fundamentally transformed is the way this works up here with these administrative agencies. It takes time to take ownership of the role we have played in allowing the executive branch to claim carte blanche on legislative initiatives. It's time to stand up for this body, the people's house, and it's time to rebalance the branches of government that have become way out of kilter and to improve the function of this body. I understand my amendment may not be considered germane to the bill, but the opportunity to speak on this critically important issue is so rare, and I thank you again for hearing me. And I request your consideration in possibly waiving this decision and restoring the legislative veto. Restoring the legislative veto would restore this institution's constitutionally delegated authority as the sole branch of government responsible for enacting legislation. And I hope the committee and my office can work together in the coming months to reconcile any issues or differences we may have, which would prevent us from moving forward on this initiative. And I thank you. That's unanimous then.
Mr. Ratcliffe is attempting to amend Section 553, and you're attempting to...
Ours is 553 of Title V.
Okay, we're amending then Section 706, and you were 553. Thank you
Correct.
very much.
Thank you.
So we're attempting Section 706, and you're attempting 553, and that's why I asked the gentleman, Mr. Ratcliffe, if there were other sections which he considered to be important to this. And so, in fact, the Rules Committee would be very open to working with you. The Rules Committee would be very open to working with Mr. Goodlatte on this issue, and I will tell you that Mr. Goodlatte and I speak on a regular basis, and we will engage that issue with you, and I want to thank you for being here today.
Thank you, Mr. Chairman.
Excuse me, we do have one person that would choose to ask a question. The gentleman, Mr. Newhouse. Gentleman's recognized.
Thank you, Mr. Chairman. I just wanted to quickly applaud the gentleman from Florida for bringing this issue forward. This is something that, in my state legislative days, we attempted several times to get on the books, to know, we unsuccessfully, unfortunately. But I think it really does speak to the issue of putting the responsibility, the power back in the hands of the people, of the people elected to represent the people. And I just applaud the gentleman from Florida for his effort here. Whether we can make it work in this piece of legislation or not, we'll have that discussion, but it's a good step forward, and I look forward to working with you on making this work at some point.
I appreciate your encouragement. Thank you for letting me come in here and talk to you.
Of H.R. 4768, and the chair would now be in receipt of a motion from the gentleman from Oklahoma, the young chairman, Chairman Cole.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee grant H.R. 4768, the Separation of Powers Restoration Act of 2016, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. Rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of an amendment, the amendment in the nature of a substitute recommended by the Committee on the Judiciary, now printed in the bill, and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to demand for division on the question. The rule waives all points of order against the amendments printed in the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for the consideration of concurrent resolutions providing for adjournment during the month of July 2016. Section 3 of the rule provides that on any legislative day during the period from June 23, 2016 through July 4, 2016, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. Section 4 of the rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed in Section 4. Finally, Section 5 of the rule provides that it shall be in order at any time on the legislative day of June 23, 2016, or June 24, 2016, for the Speaker to entertain motions that the House suspend the rules as though under Clause 1 of Rule 15, and that the Speaker or his designee shall consult with the minority leader or her designee on the designation of any matter for consideration pursuant to this section.
Oklahoma, is there amendment or discussion to that?
Yes, sir. Thank you,
Gentlewoman from New
Mr.
York is
Chairman. I have an
recognized.
amendment to the rule. I move to amend the resolution to require that the Speaker bring up H.R. 1076, the Denying Firearms and Explosives to Dangerous Terrorists Act, under an open rule, and require that the House continue to consider H.R. 1076 until we have had an up or down vote on final passage, and that the Speaker's postponement authority under Statute 1C, Rule 19, not apply to consideration of the bill. And I'd like to speak on the amendment, if I may.
Gentlewoman is recognized.
Mr. Chairman, Democrats have tried again and again to get a vote on this particular bill, denying firearms and explosives to dangerous terrorist acts. But we Republicans have refused to let us bring it up. I'm sure you know that this bill was introduced by Representative Peter King, a Republican of New York. It would keep people on terrorist watch list and the no-fly list from being able to purchase firearms and explosives. I don't know what it's going to take to convince some members that keeping guns out of the hands of a suspected terrorist is not a good idea. This proposal has bipartisan support in Congress, which by itself is rare, and the support certainly of the American people, about 90% of them or more. Till we have a vote on this important bill, we should postpone the upcoming district work period and remain in Washington. The country cannot afford to wait any longer for action in this House. I urge my colleagues in the strongest possible terms to support my amendment and to allow a vote on this bill. And I request a yes vote.
Thank you very much. Discussion? Gentleman from Massachusetts.
Yeah, I just want to be on record as supporting the gentlelady's amendment. As we have said many times over, that in the aftermath of these terrible tragedies like the one in Orlando, we need to do more than just take 10 seconds and say a prayer. That it's becoming an empty gesture that after every massacre, all we seem to do here is, have these moments of silence. And there are some of us who believe that the proposals like the gentlelady is referring to today are reasonable and could save lives. And I would just simply say to my colleagues on the other side of the aisle who keep on blocking this, if you don't like it, you can vote against it. This is supposed to be a place where, important issues get debated. And we have been blocked and blocked and blocked and blocked. And I think people are, as you see, are frustrated as what's going on the floor right now. And it's not going to stop because it's too important. And I would urge a yes vote on the gentlelady's amendment.
Thank you very much. Further discussion? The vote will now be on the Slaughter Amendment. Those in favor signify by saying aye. Those opposed, no. No. Noes have it, noes have it. Gentleman asked for a roll call vote. Clerk will poll the committee.
Ms. Fox?
No.
Ms. Fox? No. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Mrs. Slaughter? Ms. Slaughter, aye. Mr. McGovern? Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 9 nays.
The amendment is not agreed to. Further amendment or discussion.
Mr. Chairman,
Gentleman from Massachusetts.
I don't have an amendment, I just have
Yes, sir.
a question. I'm noticing in this rule, these lockdown procedures that I think both parties have used before recesses, so that, there aren't all kinds of dilatory tactics, I guess that's how you would describe it, going on in recess. But I don't ever recall it being put in a rule to apply during session. I mean, I think this takes effect, like, as soon as this rule is passed. So basically, you're closing off any kind of procedural motions immediately.
In fact, if the gentleman's asking a question, I concur.
Okay, all right, so this is a new precedent, I think.
I think it's a opportunity for the chair to move the floor as the chair would direct.
Yeah. So, yeah, again, I mean, you guys are in charge, and you can do it.
Yes, sir.
You can do whatever you want to do, but I think it's just worth noting that, that the leadership of this House continues to restrict the minority's right to be able to not only have an opportunity to debate issues that we think are important, but in this case, you're literally kind of shutting down our voice, and I think that is inappropriate. But I just wanted that to be noted for the record.
Thank you very much. Is there further discussion? Okay. Yes, ma'am.
Congresswoman Sheila Jackson Lees.
Without objection, we'll enter that
Thank
into the
you.
record. The vote will now be on the, with hearing no further discussion, the vote will now be on the motion from the chairman from Oklahoma. Those in favor of the motions, vote aye. Aye. Those opposed, no. No. The ayes have it, the ayes have it. Gentlewoman asked for a roll call vote.
Ms. Fox?
Aye.
Ms. Fox, aye. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Mr. Newhouse, aye. Ms. Slaughter? No. Ms. Slaughter, no. Mr. McGovern? No. Mr. McGovern, no. Mr. Hastings? Nay. Mr. Hastings, no. Mr. Polis? Mr. Sessions?
Aye.
Mr. Chairman? Mr. Chairman, aye.
Clerk report the total.
9 yeas, 3 nays.
The motion is agreed to, and the gentleman, myself, from Texas, will be handling this for Republicans. And Mr. McGovern, Massachusetts. I would like to still remind our committee that I don't have any clue, but we are hoping and anticipating that there will be a potential meeting on Milcon and the Zika conference report. And as soon as we receive information about that, I will be in touch with Mrs. Slaughter with the knowledge that I'm sure she would hear the same word that I, and that we would expect to convene quickly. This finishes our work for the day.
These are comments I was prepared for me to make.